Just comb your hair, go and wash your face. It's been a real long time since you've seen the light of day. So let thoughts come as they may, beauty and parade. Everybody all smiles when you're back in the seat again. All aboard the Petty Express to a beautiful darkness. It's full steam ahead to ride the rails to our next destination. Yeah!
For the boobs of all that is holy. That's it. I'm gonna make a t-shirt that says, sorry, my boobs muted me. It's just gonna be text. It's just gonna be, my boobs muted me. Some days. Wait, popcorn and grape jelly? Intriguing. But I did get the Kool-Aid lip. I tried to do the baby ponytail, but apparently it looks like she is putting it baconated and she's got framing face pieces, and I'm not fixing to fiddle with my hair right now. It looks goofy as all get out, and I'm going to take it out before I go to my son's doctor's appointment, because I don't know how anyone with this particular get up at age, what is it? She's 57, something like that. Look, them years have not been kind to her in prison. She looks straight up like Hatchet Face from Crybaby. That's why I put her in the thumbnail, because I'm going to be extra petty to a woman who used to be called a mother, a woman that used to deserve the honor of being called a mother. Now she is just ew. She is Lori Hatchet Face Vallow. I refuse to daybell this woman. She wants to be daybelled. She can do that on her own time. Anywho, let's get into this. For those of you who don't know, this trial is for the death of Charles Vallow, Lori's fourth husband. He was the one who desperately tried to get help from any corner when Lori started talking about being a translated being, about people going dark, about Ned Stark. You know, all of these things. He was noticing Lori's kind of descent into this crazy cult idea that Charles had. He was the actual DNA blood uncle of JJ. His nephew was, or I'm sorry, great enough uncle of JJ. So this is the case where Lori and her brother Alex Cox claim that Charles Vallow came into the house to when he was going to have shared visitation with JJ and did something so aggressive, threatening, that Alex Cox had to shoot him. Now, there have been many questions about this case for a long time. It was initially ruled a good self-defense case. Alex Cox was never charged with this. He has also passed away in the intervening years. So this is, you know, again, not a case that many people remember, because it was not as big as, say, the other cases. And to be fair, it wasn't as big as the other cases. So I do get that this case maybe kind of got lost in the shuffle, but it is nice to see that Charles Vallow, his relatives, and the people that cared and loved him will have a day in court. Now, that being said, let's see what this numpty of a woman decides to say. Now, Lori Vallow will be representing herself. She is fighting hard to... I was trying to figure out how you would do makeup if you only had access to Kool-Aid, and y'all, I am not good at the makeuping. Dolly, I am going to talk to Mr. Mo, since we are opening up Arizona as an idea of a place we might move. So I am going to tell him that it is vitally important that I go visit Arizona during the Vallow hatchet face trial. So we will hang out. This is going to happen. I am going to make this a thing. But let's listen to what this dingbat has to say.
Or opinions people may have had or exposure to the case people may have had, and then it has the questions where we may lose additional jurors on the trial schedule, and then victims of crime, views about police officer, and then if they've been charged or close family members have been charged with a criminal offense, and to explain that.
Well, she didn't have the baby ponytail in.
Any
I'm
comments
not
from the
wearing
state?
this piece of ridiculousness.
In terms of publicity, I think my concern would be that when the jurors come in here and start hearing about the case or hearing testimony about the case, they'll hear the names Tylee and JJ, which obviously were more, there was more publicity about those than about Charles Vallow. And so I think if we really want to ensure that the jury is unbiased and
Okay, so Lori has a deep
had
part
no
today.
pretrial publicity with regards to the
Trying to look all
defendants,
smarty,
we're going to
smarty
have
pants.
to question them as to their knowledge of her
All right,
other
there we go.
convictions.
Just look
out of
kind
Idaho.
of crazy.
That was something that was just incredibly all over the media.
I agree, but I think that may happen in individual voir dire.
And y'all go check out Salvador Dali's channel. He is a content creator. He does a lot of streams with just watching court feed and having fun. That chat's just like us, irreverent, funny, hilarious. So give Sal a check out, good Lord, that sounded bad. Give Sal a check out or a look out. Not a reach around. You know what I'm talking about. Any hoozle. Go over to Sal's channel. I have walked many miles. I have walked 500 miles and I would walk 500 more. Whatever happened to that band? We need more of that. That was the funnest song. And Betty and June was a good movie. Don't you mess with Benny and June, Hollywood. And check out Fed's channel. If Lori Hatchet Face Vallow gets you Twitter pated and you need to remind yourself that the world is indeed a good place and has good things in it, check out Fed's channel because he does scenic reviews and he doesn't even have shaky cam and you can't even hear like closed nostril breathing. It's just professional. It is great. I do think that I might never get a sponsor with the way I try to promote other people's channels. Not anyone's going to take a chance on me promoting their product when this is my general selling points. Nope, let's put you over cheer, I guess.
This initial questionnaire, if they recognize the name Vallow or Daybell and they've been exposed to something in the media about it, they should tell us about what they know about it and about whether they know about that other case and whether they know about anything that happened to it, about it. So I anticipate losing a number of jurors just based on that. But I agree with you. Some may say they've been exposed.
Sal, when did Trey Gowdy leave North Carolina and move to Arizona? Because if this judge is not Trey Gowdy masquerading as a judge, I'm going to need this. Old line read, Lori is an unfortunate cautionary tale about what happens when you stop pumping fillers into your face. Yeah, I was almost tempted, y'all, because I will tell you, I would like my upper lip to be just a scotch fuller, if I'm honest. But people putting little needles in there to fill it with, I don't know, jellyfish buttholes. I don't know what they get for the filling. I don't know how they make it. And y'all, just no. Look, I have a small upper lip. It's just, it is what it is. I can get mad at it or I can just deal with it. That being said, if I had a bunch of money, y'all, I'd probably look like a Kardashian. I'm not gonna lie. No, skip beef tallow injections in my upper lip. Make all French fries in beef tallow again. Donald Trump, I expect you to run with this mission. I really don't care about much else, but bring back beef tallow French fries. Oh, that would be a whole look and a half. It would be my whole face. All right, let's get back to Judge Bersky.
To it, but it wouldn't affect their ability to be fair and an individual voir dire. We can
Or
explore
Arizona
those
Trey Gowdy.
options. I don't want to necessarily taint the whole pool by saying, hey, she's got these.
He just said taint the whole pool. I never want to see anyone taint a whole pool. That would be exhausting, having to taint all the places.
Convictions in this other state.
And Your Honor, I don't propose we talk about the convictions, but we will hear the names JJ and Tylee in this trial. So that's my concern, is if we don't raise those names, whether or not we put them in the list as people that they may hear.
What I could do is on question 15, where it lists out my name, the court staff, I need to include your name, the attorney's names, the advisory council's names in there. I'll add those. But at the bottom where it says other potential witnesses, I could do a third or another category that says other people that may be referenced but are not going to testify unless those names. That's fine. Is there any in addition to those two?
That would be the only for that. I think the other issue is, of course, the defendant's supplemental 15.2 names.
When was that filed? I haven't seen it.
I filed actually 2 motions to preclude them all and emailed them to your court Sunday.
Okay, maybe that's in my folder that's on my desk. Before we,
Seems like, Lori may be facing the same sort of problems that Daryl Brooks and Sarah Boone and many people who aren't lawyers face when they try to, conduct their own felony murder case. It seems like, from what I'm hearing, Lori decided to put a bunch of supplemental witnesses in that, aren't related at any way to this case. Kind of like the whole Daryl Brooks, my mama said, there was a recall. This would be one of those motions like my mama said.
Filed that on the 12th of March.
okay, before we get to that, let me ask the defendant. Other comments on the proposed questionnaire and the information that we're going to put in there?
I think it's
But Dolly, would the Jesus that's going to exonerate her really appreciate her going scorched earth? I mean, I know she's a translated being and therefore much holier than I am, but as a not so holy person, that math doesn't math. Because I'm pretty sure. Wait, so Chucky, this was actually a fairly big case. Lori Vallow, she was called the Doomsday Mom. She basically started an affair with Chad Daybell, a fiction Mormon writer, LDS writer, who had some really strange ideas that because he was close to death, he had seen beyond the veil and had all of these sort of cognitions about the end times and how the 4400 of the Bible would be led to Rexburg, Idaho. And Lori and him met up at a prep kind of survivalist conference, I guess, and started an affair. She was already married to Charles Vallow. She had adopted his great nephew, JJ, and had daughter Tylee with her third husband, Ryan. Oh, something or other. I'm sorry, my name thing is breaking at the moment. But the thing that really propelled her into the news was the fact that her children went missing, and for 3 months, Tylee Ryan, thank you. So, Jake Ryan. But basically, Charles started noticing a giant change in his wife. She started claiming that he was no longer Charles Vallow, but he was in fact this person named Ned. That he had basically his soul had been invaded by a past life named Ned. Ned had apparently pissed Lori off in a past life, and he was dark. So with all of this sort of cult overtone, the real brass tacks of this case is that Lori wanted to move on to a new life with Charles Daybell, but she realized that she had grown accustomed to being sort of taken care of. Charles Vallow was a successful businessman. He was, Old Line Red, I am not quite up to date on that, but I will have to check it out because I haven't seen that. I will tell you guys that I am trying to keep up with all the cases and I am failing spectacularly. Again, I apologize. I did not expect this winter to kick my butt as hard as it did. And then as soon as I thought spring was breaking, unfortunately, we lost my mother-in-law. So it's just been like a couple of sucky last couple months where my brain is ready to run on a bajillion miles an hour and my body is like, heifer, we are at sloth level for Zootopia. No, it's not that. I feel bad for you guys because I've got so much that I want to do in my head, but it all kind of depends on my room being done and, being able to set up different ideas that I've had. So I am not practicing patience very well, as I tell my children, because we're never going to get patience right. It is our family. But if we could practice it, maybe we'll get better at faking it, is what I always tell them. So it's getting done, but it's just not getting done as fast as I want. However, after that sidetrack, this particular case is about the fact that Lori Vallow and her brother, her kind of ride or die, Alex Cox, claim that Charles Vallow, in the middle of a child exchange for JJ Vallow, became so violent and aggressive that he had to be shot, unfortunately. And he did pass away. Now, this particular case was kind of seen as a self-defense case for a while, but after shady things, the children not being around and all of that kind of came out, this case got a, closer look and review, and Arizona decided to charge Lori Vallow with conspiracy to murder Charles Vallow, because underneath all of this shenanigans with the cult thing and the Ned thing and the translated beings, the dark beings, oh, excuse me, my stomach just apparently let loose a demon from hell. I don't know. Y'all, I ate a waffle, like I ate 3 waffles yesterday. Things have not been tasting great and 3 waffles sounded good, so I just ate 3 waffles, and apparently one of the waffles was possessed by Satan. I don't know. Good Lord. Anywho, that's what you heard tonight. But below all of that, down to the brass tacks of this case, it does seem like Lori Vallow had gotten accustomed to a certain level of luxury in her life. And she was, going to use, and she was the primary beneficiary for Charles Vallow's, benefits, death benefits, insurance for a long time. Look, don't be talking bad about my Coke Zero. Look, I'm attempting to give up either caffeine or nicotine, but for the safety of my family, I don't know which to figure out first, and it's going to be a slow withdrawal because safety for everyone. I don't look good in orange. Now, she wanted his life insurance, and the bitch fit of epic proportions that happened when Lori Vallow found out that Charles Vallow had changed his beneficiary to his sister was immense. Now, that is kind of the basis of this entire story. Now, Lori Vallow has already been given a life sentence without parole for the deaths of her 2 children, Tylee Ryan and JJ Vallow that were found, their remains were found on property that was close to Chad Daybell's home, close to a burn pit. JJ was, wrapped up, his face and head covered in plastic. And poor Tylee was burned, and it looked like just desecrated beyond all belief. But she was shot, I do believe. So this is and Chad's wife Tammy was also strangled. That case was labeled a COVID death or something like that at first, some sort of unknown heart thing or something like that. But it is just a terrible case, and I hope she gets all the life and all the, because she is just a horrible, horrible person. Now, we have yet to go over the interview she did. That will probably be the next thing we do this evening. But let's get through these hearings. Apparently, in the next hearing, she is a bit of a butt buffoon. No, butt bassoon. She's a bit of a butt bassoon. So I am anxious to see her trying to get her little snippy on. Because, ma'am, you are no longer in the position to yell at some little worker at Target and ask them for their manager. So I don't know where you are getting airs from, but I don't think you can get high and mighty in Hades.
What's that?
Pretty clear.
Okay, do you have any objection to listing Tylee and JJ, because they will be mentioned?
No.
Okay. All right, let's take a look here. Let me ask the state, you have 21 witnesses listed. I need to look at the defense witnesses that were listed.
I was wondering that. That's a fairly
And we're
fresh.
after jury selection. I
funky
recognize jury selection could take longer than the initial week that I've set forth, but from April 7th to May 15th, the current screening, that is 20 full days of trial and 2 half days, so essentially 21 days of trial. Do you really think we need to screen that far out? I know you're being overly cautious.
I think, especially given that I'm not positive we'll pick a jury in that first week, I think we should, Your Honor.
All right. Defense have any comment on how we're screened through May 15th?
I think it's plenty of time, Your Honor, myself.
All right, let's deal with a couple things. First, I've received the notice of compliance. That was when the defendant requested the Gilbert video. Does that apply to the second case or this case?
Your Honor, it's an incident that occurred in January. It's not really, it was disclosed because it is mentioned in the DR. The defense had filed a motion for the state to disclose that, and then had brought up again on the 11th that the state had not disclosed it, that there was some YouTube video of that. I have looked for said YouTube video. I have gone through the police report. I don't know what video she's discussing, but we're not aware of any video that hasn't been disclosed. So I'm just providing notice that disclosure is complete as to that police report that is peripherally relevant.
All right. Any comment on that?
Yes, Your Honor. For clarity, is the state proposing that there is no video or that they don't have to give it to me because it's not attached to that DR number?
I think what she said was she's not aware of what video you referenced. So as far as her knowledge, she doesn't have it and doesn't know about it.
So I should go directly to Gilbert Police Department to get it?
Well, last time you were in court, you said your investigator
Oh, for flippin' flapjack's sake. Between my stomach, my boob, and myself, we're just gonna mute me from now on, honest to goodness, one of these days. Any hoozle, ma'am, I don't know where you're getting your snippy snappy tone, but you are in prison. In fact, you have a pair of hardware that are keeping your hands very close to each other. So I don't know where you are getting this Target, like, Kohl's, Neiman Marcus, you better bring your store manager tone up. But this is the judge, not a manager of a box retail store, ma'am. I'm gonna need you to slow your damn roll. Not to mention, you are not a queen. You are a convict, and you're convicted of the most heinous things, so shut the hell up.
Or someone told you about it,
Fair
A
point.
mitigator.
a mitigator,
Showed it to me.
if they have that link, why don't they just send it to the state, and that may help the state determine if that's something they've already disclosed?
I will tell you why they won't, because that is my former team, and they will not do anything to help my investigator, my paralegal. They won't give us any information that they found. They won't talk.
On the truck, and Dodge Ram it for whoever wants to know, but she can go take a long walk off a short pier. I don't know any car related things. That's all of my carology. So I was going to be like, she can go rolling transmission fluid, but I don't know if that's good for you or bad for you. And I was kind of hoping it was bad for you. And Frenchie's mom, my daughter has the same hair, and in summer she got the same highlights in her hair. Even other parents asked me if I had highlights in her hair at 10 years old. I will say my younger ones get a lot of highlights in their hair. And they end up looking like the children of the corn, because it's just like super pale towhead blonde and super pale kids, and then me. I'm the only one that doesn't match.
To us at all because apparently there was a conflict. So they will not help us. They will not send us anything. They will not email us anything. They will not answer anything that we ask them to. So that has been the response from my former defense team. That's where we are.
All right.
Someone's not bitter at all.
Do you know, and maybe your advisory councils can speak to this, did they turn over a file to you, or did you have to start from scratch?
No, from what I understand, all they turned over was the 22 terabyte hard drive, and that is it. They didn't turn down any notes, any work product, nothing that they had done to that.
Okay, question for Old Line Red or any legal people in there. The old defense team doesn't have to give any of their work product, do they? Because, I mean, that would be something that they worked on. That would be considered work product. I would think it would be domain of, whichever legal facility or legal practitioners made it. I don't believe that she's entitled up to it. But she is going to get here just absolutely see you next Tuesday, E. Because she can't get it. Also, I can't tell you guys how much I love this pen. I feel so fancy, and it writes so well. Anywho, I'm just getting some notes, trying to be smarter-ish about things.
That point. Continue to stand by that today, even though a lot of that information I gave to them, they would not give it back to me.
Are we getting some Sarah Boone vibes here? Are we booning a little bit? Are we Sarah Boone's farming it? Dizzy, I put in fountain pens on Amazon, extra fine nib. I write incredibly small and incredibly doctorish. So that is kind of, I like that it's very smooth. But I will try to send you the link of the actual thing, but I just put fine nib in, and this was about $30, I believe. Now, well, we are detecting some Sarah Boone entitlement vibes, and my lawyers never knew what they were talking about. Not by choice. I have had 8 lawyers not by choice. Is Lori Vallow going to do the not by choice and it was unintentional? Dear Lord, please. Tiny baby Jesus and the gods that control court TV, please let this woman say not intentionally, just for me. It's been a rough year. Come on now. I need this in my life.
All right. I'm going to make an order, and it'll be in the minute entry that they turn over a copy of their entire file, including any mitigation information that was gathered to the advisory council to makes Hicks, you look like you want to say something.
I don't know.
Yeah, I mean, oh my gosh, that would be bonus points and the cherry on top if she used futuristically.
No, I'm good, Your Honor. Thank you.
All right, so I'll do a more detailed order about, they should have turned over a copy of their entire file to,
Oh my gosh, I want to do a picture with disappointed Jesus from Your All Disappointment with God's favorite on it as a t-shirt. And he's just looking at me disappointed. I think it would be funny. This is why I don't have a Cricut, because I just be making stupid t-shirts up, and I don't need to be wasting time like that. And we don't have enough t-shirts in the world. But for Lori Vallow, I will make God's favorite, her face and disappointed Jesus. Actually, just her face and God's favorite, I think, might do. But I don't want to give anyone nightmares. She's just being a butt monkey. She's pissed off that her defense team left her and she's stuck being pro se. So she's going to be an absolute twat waffle and claim that they didn't give her her stuff. I am entitled because my constitutional rights. My
advisory
constitutional
council when
rights.
they withdrew.
I know, I'm kind of scared about that, to be honest. This is a new charge. She has already been charged with and gotten life in prison for the deaths of Tylee, JJ, and Charles's wife, or Chad's wife, not Charles. She's Charles's wife, Chad's wife. So this is a case that we didn't know if it was going to go forward because she'd already gotten life in prison, you know, up in Iowa or Idaho. So we kind of wondered if Arizona was going to move forward with these charges, but it looks like they have decided to do that. And Lori must have, I will have to look up the backstory as to why Lori doesn't have defense and she is pro se. I was just so giddy with the fact that she was going to be pro se that I didn't look deeper into it. Well, I'm glad we are watching her sort papers. Do they really make them wear orange bras too? That's just a bridge too far. I will fight for constitutional right. Orange bras? Oh. Sorry. No, I was trying to take notes and do all the things and speed up as they're just looking through papers and not talking.
So I've read the defendant's disclosures that were filed March 6th and March 12th, as well as the state's motion to preclude. And, well, let me start. Have you received any response from the defense, anyone from the defense team since you filed this on March 16th?
Your Honor, last night at 10:30 or so, defendant's investigator sent over a list of the addresses of the witnesses. I did speak with him this morning. I still am unclear if defense will be setting up those interviews or if they will be providing phone numbers to the state to set them up ourselves. As for the expert, again, last night at like 10:30 at night, defense investigator emailed the state and indicated that the defense expert would need to or wanted to obtain the physical laptops and cell phones that the police had impounded so that he could then review them, do his own self-right or extractions. So obviously the expert hasn't even begun work, let alone, they've also requested all impounded items from law enforcement. I'm unclear if they're asking for ones that were impounded in Idaho as part of their investigation or just the ones here. The statements from the investigator appears to be all of them, which would mean the state would have to request Idaho to send those to the investigator. So again, given all of those issues, I don't see how that it would be possible for the state to provide that to the expert prior to this trial beginning, let alone to get a report or an opinion prior to this trial beginning.
All right, let's set aside Dworkin for the time being. So you're,
No one puts
well, let me
Dorkin
ask the
in a
investigator.
corner.
What's your name, sir?
Jeff
Jeff what?
White.
Okay, Mr. White, are you going to be setting up interviews for the state to interview whatever potential witnesses the defendants noticed?
I'm trying to verify, excuse me, sir. I'm trying to verify the phone numbers to be correct. I do have a few of them, but some of them I'm trying to make sure that these are the correct numbers.
Okay.
I did the searches for them, and I have to apologize. I left yesterday, and for some odd reason, my email just did not go through. So,
Your Honor, my understanding is that the state has interviewed every single person on my witness list previously. That's where I got the people from the interviews that they had from the state previously. So I understand that they're allowed to do another interview of them, but they have interviews of every single person that is on my list, with the exception of one,
Which is who?
which is Nate Eaton.
Okay.
Oh, for flippin' Flapjack's sake, she's going after Nate Eaton. This bitch. Good luck with that. Nate Eaton is like Steve Gosney. He's just one of those happy people that need to be protected because the rest of us are cynical assholes and we need their like human light and goodness to remind us that there are good people out there. So you better keep this heifer away. This swamp donkey hag, $50 Barbie sea witch out of... Ma'am, I have never felt like Will Smith so much in my life, but you keep Nate Eaton's name out your mouth. Oh, dear Lord. There is no way that he has a nexus to Charles' case other than the fact that he might be covering it. She is pissed off because he exposed her. No, he was the guy that she's like, well, that's good. When he was saying, everyone's praying for your children. And she was in Hawaii with, Chad Dorkbell, having their Hawaiian, kidless vacation because they done unalived the kids, but no one knew that at the time. So she is just mad that he exposed her as the conniving swamp donkey, $50 Barbie at a garage sale, looking hag self.
When you say the state's done the interview, do you mean police or someone from the prosecutor's office?
In discovery, I have interviews with police on every single one of the witnesses that are on my list.
Nate Eaton?
So I know that they had their addresses. I know that we were trying to get the addresses to them in the quickest way possible. And where I am at the jail, the communication is very difficult for me to get a hold of my investigator, to get a hold of my paralegal. I'm 23 hours a day locked down. If I don't have Wi-Fi, I don't have a phone. If I don't have battery, I don't have a phone. I don't have access to get to people. So I understand that. I understand the time constraints, and we're doing the best that we can of getting things answered, getting things put together.
So as a threshold question, your assertion is that all these people that you've listed in your notices have relevant information for trial?
Correct.
And do you know if the police have interviewed these people?
Your Honor, the
They may be
first
referenced.
listed person is a reporter, so I'm not really sure the relevance of a reporter.
He's the only one that hasn't been. So
He's the only
That's what I
one. He's the one I want to skewer on the
So, Your Honor,
testifying
the point
stand.
is to start with, one, these people, I'm not sure all of them actually have been interviewed. Those that have would have been interviewed 5 years ago. So whether or not their addresses are correct, unclear. It's not the state's responsibility for the defendant to do the defendant's work and find these people. I have an absolute right to do interviews just as the defendant does. So in terms of the witnesses, I think that most of them, as best I can guess, would be character evidence, which would be improper under 405. So depending on what they say, then I need to file motions to preclude or motions in limine for any or all of these witnesses.
All right, so it's premature to address these today. The state's going to have to interview them, and
Dolly, do you happen to have a list of the witnesses she's wanting to bring in? Maybe we could do a stream of seeing who she wants to bring in and what connections, if any, they have to these case or this case, or if they're just people that did a blog about her that she doesn't like. Ooh, Lori, please call me in. I have some things to say, and I'd like to get them on the record. Your Honor, if you could have the court reporter write this down. She is holding up 2 middle fingers and twirling them around like a tornado. Thank you, Sal. Maybe we will have a Lori Vallow run-up thing. Unless you're doing one with EU, then I don't want to look. I was just going to throw it out there. Oh, I am ready to let another prosecutor come on the Petty Express. Giggity. But just the tip, ma'am.
find out if, in their opinion, they have relevant information or not. And then if there's a dispute out there as to whether or not they'd be called, I'll have to deal with that as it comes up. But if they're unable to be located or interviewed, obviously they won't be called at trial.
Lori's like, this is not fair. It's just not fair.
Mr. Dworkin, if you want him to do extractions, you're not ready for trial. So in order for him to do the work that he's requesting, getting copies of a laptop or a cell phone or whatever the case may be, that's going to take him time to extract and analyze and then prepare a report, months maybe.
I understand that, Your Honor, and I'm hoping he can do it in an expedited manner. I requested him from OPDS on January 14th. He got approved on March 7th
Well,
from OPDS.
you're the one pressing for your speedy trial, so you kind of have to make a decision on, we're set for trial. You want to go to trial or you want to have him do that work that you want? Because I don't think both are going to happen. Even if you got the laptops today, generally,
I will have to see if Jedi Jess can pull the Lori Vallow filings in this, and we will go over all the shenanigans. I have a new Petty Express target for, you know, shenanigans and snark and all of that jazz.
those types of things can take weeks, even months to analyze and prepare a report on.
I understand that. And I also understand that I've only been given 10 hours for him from OPDS, right? So if he could spend 10 hours this week getting
Yes,
them ready,
JW, this
then he can
is.
give us a report with the best that he can do.
Oh,
Well,
thank
the
you,
report's already
Dolly. I
late
appreciate
technically,
it.
but if it were allowed, first of all, it's gonna take time to coordinate him getting let's start here. Specifically, what are you requesting? Because the state wasn't clear whether you were requesting items here impounded by a particular police department or items that may be impounded in Idaho.
Well, I'm sure that my investigator would like to have all of those things done, and I realize that we're on a time constraint, and I would be only concerned with one item, which is at Chandler Police Department, which was Charles, my husband's phone. Charles Vallow's phone.
Fuck you sideways with a cactus, ma'am. You had this man killed, allegedly in Minecraft, not adjudicatedly yet. But do not call this man your husband like it is your right. No, your former husband, your deceased husband because of you, but not your husband, you gross, disgusting, corroded, swamp donkey hag. I mean, you make Hatchet Face look beautiful. So, ew. Just ew. And yes, please make sure you do all the YouTube-y things so the algorithm knows that you love me. You really love me. Here. I'm gonna practice to be like those public defenders in the last trial. Those two, y'all, I'm just warning you that my final thoughts for the Stacey Rodriguez trial is going to include a rant with a tapestry of curse words for her defense team. It was it was the worst display of unprofessional behavior that I've ever seen. And I saw Owens in court and sat through Lolly.
And I would like a copy of the extraction that they took from it, the digital forensic extraction from Chandler.
You absolute dumbass. That would be in your discovery, ma'am. If it was an extraction from Charles Vallow's phone, from his, murder scene, then yes, the police would have it and you should have gotten it in your discovery, you giant Muppet hag.
Their police could be given to him immediately. That would be very helpful.
Wasn't that already disclosed?
Yes, Your Honor.
Was that part of the initial terabyte?
Yes.
Excuse me.
Yeah.
Everything that I have is on a 22 terabyte. So if
Hard drive.
hard drive, so if I give that away, I can't do my work.
Well, can't you make copies of files out of it?
22,
Arizona is going after her for the murder of Charles Vallow, her fourth husband. So the husband that she had to get rid of, but keep his insurance, so that she and Chad Daybell could live happily ever after until the Lord made the second coming, and they were going to usher the 44,000 into the promised land in Rexburg, Idaho. Now, if none of that makes sense, that's probably because down beneath all the cult shenanigans, she wanted Charles gone, she wanted to be with Chad, and Charles had $1 million life insurance that she thought she was still the beneficiary of when he passed. She turns out to have not been on there because Charles thought she was crazy. And the most heartbreaking thing in this particular trial is that Charles reached out to so many people to try to get Lori help when she was acting like a ridiculous, child who had fallen into the never-ending story, into this, world of make-believe Harry Potter, zombies, dark entities that Chad Daybell told her. So it is incredibly sad that the one person who, was sounding the alarm before the kids got hurt, before Tammy got hurt, before any of this happened, no one would listen to him. And it is, sorry, I have got like a piece of hair that is just, there we go, sorry. No one would listen to him. And it's incredibly sad because he was the first one to say, hey, something is wrong here and someone is going to get hurt. This is some really dark stuff they're talking about. She has threatened to take me out. in Old Line Red. I still think her finding out about Kay being the beneficiary was the best moment in the whole flustercluck of that case. Yeah, her losing her ever-living poo while trying to maintain the Disney princess voice. We're always happy, always kind, even when we're a cunt. So that was really interesting because she switched from Disney Princess to Swamp Agatha Roseanne singing the national anthem. And it was great.
Terabytes.
I understand that.
Okay.
So what's your proposal?
I'll take it up.
I mean, if you have all that information in a file, I'm not saying you have to copy the whole 22 terabytes, but there's a file in there somewhere that's the Cellbrite extraction already for that requested item that's been in defense possession for however long now.
I'll take it up tomorrow.
So I'm happy to make an order, but again, if he's not done with that information you want, are you still,
I don't believe there was a excuse me, a video of that in the Lori Vallow, excuse me, the Lori Vallow case. I think it was audio only, but when Kay Woodcock testified, she was the maternal grandmother of JJ and Charles's sister. She was the one that ended up being the beneficiary of the, insurance payout, basically. And Charles had talked to her about the, kind of very creepy behavior that Lori was displaying. But when Kay Woodcock was testifying at those trials, it did come out that Lori was extremely upset, sent her a bunch of text messages about her being evil. What was she going to do? She has 2 children. How could she think of being the beneficiary of this thing? Sending, I'm gutted sort of messages to Chad. Sal, is there a death penalty option here? I don't believe Arizona has the death penalty anymore because I believe Jodi Arias, they were thinking about going for the death penalty. But if her case didn't warrant the death penalty, then I don't know what does. So that being said, I'm okay with it.
wanting to proceed to trial at the end of this month?
Yes, Your Honor.
Okay.
Do you know what's really fun? Making a website on Wix.
What the hell is this?
Hey, we're how ridiculous. 3 childhood friends.
Would have to have an
I
opportunity.
have no
to
idea. I
consult
have
with an expert.
premium.
Secondly,
How in the
it's
hell
late.
did they add an
Depending
ad?
on
I
what his
have
opinion
premium.
is,
Do you know what's really
No,
we're
I don't.
under the rules of evidence and rules of disclosure. And secondly,
Oh.
depending on what he says, the state would,
Okay, Sal says they do have, you guys do have the death penalty. Arizona might just have moved up, allegedly in Minecraft, just joking. And Jodi almost got the death penalty, but the jury wouldn't go for it. To be fair, she has aged. She has not aged, which is upsetting. Maybe evil really does keep you looking well. I don't know. I like the prison flats, but I'm really confused about, oh, you have got to be flippin' flapjack kidding me. I hate you, lawn crime.
have to have an opportunity to consult with an expert as well. So even if he got something done, it could still be precluded, but I'll give him the opportunity to do whatever it is that you think he needs to do to analyze that. But that information's been in defense possession for months, if not over a year.
More than a year, Your Honor.
And he was just approved by OPDS last week, Your Honor.
I thought you said he was approved. You applied in January.
I applied for him in January and last Friday, he got approved.
Again, this is one of those things where you have to weigh your options on whether it's worth it to get a continuance so you can have your defense do the work that you want done on your defense. But if you're telling me you don't want to do that,
I would like to do that, but
And then Old Line Red said that Lori's Idaho team got the death penalty kicked over discovery violations, which is probably why she keeps saying she doesn't have discovery here, even though she does. Thank you for that insight, Old Line Red. I was wondering, I mean, she has had a year, and, you know, she would be, I would think, vaguely familiar with, even though it is a voluminous case, at least, you know, some major points in her case. And I don't know what led to the departure of her, you know, defense case or defense team in this case. I would like to find that out. As per always, you know, I am flying by the seat of my frippin' flapjack pants. But essentially, it seems like Lori is going to have to make a decision. Now, it does seem like she went in with the, you know, we're just going to go with a speedy trial instead of continuance because it looks like they're starting jury selection next Monday. If I was, you know, reading Sal right, which, you know, sometimes I need to slow down to make sure I read Sal right because I sent everyone, you know, he was celebrating his sobriety and being a good boy. And I was like, I guess Sal is drinking again. So, you know, Mo needs to slow down and read things correctly. But as a personal aside, Sal, you are inspiring me to make small changes in my life as well. You made a big change and have stuck with it, and I am going to try to make small changes and stick with them. So thank you for sharing, you know, what you've been doing with your life because it really has inspired me to make some small choices to do for the better. Not big ones. Look, y'all. So she's really going to have to make a choice, sorry for all the tangents, between a speedy trial, which it seems like she chose, or a continuance to get all of her experts in. Now, what she might be assuming is that she's just not going to be able to get a fair trial and she's going to muck up jury, you know, voir dire. I do hope that they do publicize or stream voir dire. I think it will be extremely interesting to see the number of people who they're able to pull that, you know, they think can be unbiased and look at this case in a very, you know, open and professional way. I doubt that's going to happen. I would wear my jury nullification shirt that I puff painted the night before. Actually, I wouldn't because I want to be the one to send her ass to, you know, second jail, but that's just me.
my situation in my housing department precludes me from doing that.
from asking for a continuance?
No, from getting things done in an effective and quick manner.
Okay.
Hey, you giant swamp donkey, I don't want to help you because mainly, you know, you don't help your enemies when they're screwing the hell up. But what your judge is trying to subtly and not so subtly tell you because he's not allowed to instruct you in, you know, the vagaries of law and all of that crap. He's telling you that you don't have time to put on an effective case if you would like experts because you are running out of time. So you can either choose a quick and speedy trial with very little preparation in which you will say that you didn't have effective counsel because you are your own counsel. So I don't know if, you know, counsel stupidity when you represent yourself is a thing, but I would try it, Lori, if you're gonna. Or you can wait and actually have a good trial. I don't know what she's planning here. I don't know what, you know, Jesus's voice in her ear hole is gonna say. But let's continue this because it seems like I'm in prison and they're mean is the main theme of this particular, you know, hearing.
All right, well, so you're telling me you don't want a continuance because any information he has at this point could be precluded as being untimely.
I understand that is the rule, and I understand how unfair and prejudicial that would be to me.
Okay. So I guess I'm gonna have to cross the bridge on whether these,
Hey, X in the chat if you give a crap if Lori feels that it's unfair and prejudicial. Now, I'm going to tell you that I would rather watch Kevin Spacey do semi-naked burpees in Walmart than give a crap about what's fair and prejudicial to Lori Vallow. So, I don't know. You know, your personal give a crap less could be different than mine. So she was mainstream LDS until she kind of broke off into this, really weird offshoot semi cult of Chad Daybell. He was sort of trying to form a cult. So, yeah, I'm sorry. And well, Lori, if you had lawyer or attorneys who don't live in a jail working on your behalf, this whole thing would have been much easier. Yeah, I do need to let me Google as I run this why they, parted ways.
Notice defense witnesses are even able to be located and interviewed before I make a decision on whether they have relevant information and can be called at trial.
Obviously, Your Honor, we have a little over a week to try to interview these people, so
I
I will
understand.
file something at the end of next week indicating who I've been able to reach and interview and ask to preclude everyone else.
All right.
They also obviously ask to preclude them regardless,
Right.
based upon what they may say.
All right. What else do we need to address today then?
Your
From
Honor,
this-
the only other motion that we did not address last week was the state 609 motion. I presume the defendant will likely testify, so I didn't know if we wanted to address that now.
Are you prepared to address that now?
No.
I generally will, I guess I'll advise the defendant now that if you choose to testify, it's likely that the jury would.
So what Google is saying is that Lori Vallow's public defenders stopped representing her in Arizona because she chose to waive her right to counsel and represent herself after being deemed competent for trial. Following a Rule 11 hearing, doctors determined that Lori Vallow was mentally fit to stand trial, and the state could not object or did not object to this finding. After being deemed competent, Vallow decided to represent herself instead of being represented by the public defenders. Vallow chose to waive her right to counsel, meaning she could would no longer have legal representation, instead would represent herself in court. Okay, so I thought it was because, maybe there was some sort of disagreement, Sarah Boone style, but it seems that Lori, those voices in her head said that she would be much better. And I mean, if you are one of the chosen sainthood of the, Chad Dorkbell cult, I'm sure that the Lord will protect you. I mean, go ahead and try it, ma'am. I kind of want to see it. This is going to be a shit show right next to 3 Mile Island and Chernobyl. So let's see it.
It's a bold strategy, Cotton. Let's see if it pays off for him.
Hear about the convictions. But at your request, they could be sanitized, meaning that they would only hear about the fact that you have convictions as opposed to what the nature of the conviction are. But that would be up to you, whether you want that information out or not. And then the jury would receive a limiting instruction that the existence of those convictions is only to be used for the purposes of determining credibility. So you should be aware of that when you make a decision on whether you want to testify or not. Oh, if you do want to testify, it will be question and answer, meaning you need to write out all your questions that you want to be asked and have one of your advisory counsels ask those questions to you when you're on the witness stand.
Right.
Okay, so you can't take the witness stand and just give a narrative. It'll be question and answer.
So am I supposed to reply to the 609? Is that what you're saying? And ask for it to be sanitized if I want that?
We can talk about that when we actually have a 609 hearing, but yeah, you can make that request orally. You don't have to do a written response. I indicated last time for your opening statement and closing argument and questioning witnesses that you'll pretty much be limited to the podium. We'll be in a different courtroom apparently for trial, but it'll be set up very similarly. Either your investigator or one of your advisory counsels will
No, I like to
approach
first
witnesses with
want-
exhibits if you have to show a witness an exhibit. So I'll have to do the same limitations on the state. The state would be,
Oh, and I want to say Mrs. Nutter Butter, but I love the squirrel. She's a good squirrel. She's the bestest squirrel. So in some places, yes. And then you get public defenders like the ones that we had in the Stacey Rodriguez trial, who are public advocates for narratives for third wave feminism. It was gross. The more LDS members on the jury, the better. When I was in Arizona, the LDS were the hardest on these cults or people that made LDS look bad. I've heard that Mormon, or the term Mormon is now a slur. I don't know. I don't try to intentionally offend anyone but Sarah Boone and Lori Vallow. So I'm trying to say LDS more than Mormon, but if I slip up, y'all, look, it's just what I've been calling them for daggone near my entire daggone life. So give me a second and a little bit of grace.
confined pretty much to the area of the podium, and the state would have someone assist in approaching witnesses with exhibits and that sort of thing. All right.
I have some motions that I'd like to file. I've had a really hard time getting, my
copies
paralegals
for the
very
state?
busy. I don't have copies.
All right, we'll make copies and give them to the state, and then we'll file them, and depending on what they are, I'll rule on them as the response and replies come in, or we may have to address them, depending on what they are. So plan on that questionnaire going out. I think we said, next Thursday, the 20th, will be sent out to potential jurors for the first batch of jurors, and then the responses would be cut off on the 26th.
Judge is going to be sent out Monday the 24th and will end on Monday the 27th.
All right. And then I'll meet with the
How did Ultron get into the room?
parties on the 31st to go over those remote responses. So that'll be the 31st at 10:38. Then again, I'll just reiterate on April 1.
Maybe it's Satan?
Are we having we're not having walk-ins, Izzy, until the 1st?
Correct.
Okay, and then on the 1st, we will meet again, and for the rest of that week, we'll likely be meeting at
I will work on
10:30
that.
and
That
continuing
reminds
with
me.
jury
Let me put
selection
it down
every day.
in my list. I'm trying to
Until we
be
get enough
better
jurors.
at
Hopefully we get
writing
enough
things
the
down
first week.
so I,
If we have
because
to,
I
we'll go
don't
into the second
remember
week.
them. I was like, so I remember them. I'm like, because I don't remember stuff.
Judge, I know that I'd given you a date that I was going to need to be dark on. I'm going to put out there, since I obviously don't know when we will get the jury picked. I do have some witnesses that are flying in, so I may have some days where I may need to end a little early or whatnot to try to accommodate some witness schedules. But I'll keep the court updated once we get a jury picked.
I
and
think we'll have a good idea by about day 2 of jury selection, whether we're gonna need to go into the next week or not. That reminds me, though, is I would like the parties to plan on, we're gonna have a much better idea after about the second week of trial and the first trial, how the second trial will unfold as far as how many jurors we might need, but I would like the parties to plan on doing another remote questionnaire with a much larger pool for the second trial and meeting on Friday, May 30th. I'm just giving you a
think
heads
so.
up as far as this is concerned. And then for scheduling purposes, so everyone knows, I'm planning on probably going Monday through Friday of the week of June 2nd, as well as Monday through Friday, the week of June 9th, to try to get as much done as we can. And then there's going to be some dark days there toward the end of June.
It's a
But we
Lori
need to get it
Vallow
done by
trial.
July
There's going to
4th.
be a bunch of dark days.
Your Honor, when are you planning on starting that trial?
So jury selection would be starting May 30th. All right, anything else from the state for today? If you want to stick around, we'll get you copies of those motions.
I do. Your Honor, I guess the only other thing is, for the questionnaire, are we going to put in the defendant's 15.2 witness list?
I'll put in those names preliminarily. It doesn't hurt, just in case anyone is called from that list. And if anyone knows any of those people, I will put that in, actually. Anything else from the defense?
So I'm unclear on where we stand with the video that I requested.
The state says they don't know what video you're talking about. They've disclosed everything they have.
I am going to really need to get that voodoo doll so I can show where in the brain Lori Vallow hurts me. Because right now it's the tempular area. Right here, it's like a little teeny tiny hammer because her stupidity. He already told you, Junior, that it is in the discovery that you already had. Oh no, Mr. Bill. Seriously, were you not paying attention at the beginning of the entire, hearing we just had? Because he said that it is in that terabyte of discovery that you've had for over a year. You're the one who decided to go pro se because, I don't know, whatever Jesus glitter that you huffed in your, Quaalude high dreams gave you the idea that you'd be a great lawyer. But no. So he already done told you it is in the discovery that you have had for a year.
So I'm going to make an order to your prior team to give you whatever that is. If you have a link in that information, you can forward it to the state so the state can see if that's something they've already disclosed or if that's something Gilbert didn't give them, or on the other hand, since it was told you secondhand or showed you secondhand, whether it's something different than what you thought it was. I don't know. So I'll make an order that they...
Who do I think is worse, Lori or Ruby Frankie? I think they're both hags. I don't think there's a worse in it, because Ruby Frankie basically destroyed all of her children's souls and gave them work for a lifetime to try to unlearn all the trauma that they had to deal with that crazy woman and Jody Hildebrandt and the whole upheaval of their family, and then her videoing their private moments their entire life. And then there's the other portion of Lori took her children out of the world, so the world will never get to experience what JJ and Tylee, would be able to experience. So I think they're both the worst, just in different ways. One consigned, the world to never know her children, and the other consigned her children to a lifetime of emotional pain and doubt and stuff that they're going to have to figure out. Ruby Frankie doesn't have to do all the hard work to unlearn the bullshit that she gave. True that. Lori the most. Oh my gosh, that's the t-shirt. Jesus loves us all, but loves Lori the most.
Hand over all those things to you so maybe you can figure that out. But at this point, the state says they've disclosed everything that they have and everything that they're aware of.
And in that order, they'll give it to my advisory council, or who?
Who do you want me to, I was going to say give it to your advisory council. Do you want a more narrowed order? Maybe any mitigation work that was collected, or do you want a broad order that's basically everything in their possession?
Well, it would be nice if they could turn over everything in their possession that we worked on.
I was just thinking
together.
it would be easier for you maybe to find that needle in a haystack.
Okay, he is being way too nice to her. I say give her the entire terabyte. Do not help this woman. Judge, I understand that you don't want your courtroom to become a circus, and I do get that. I really do. But do not help this woman. She is bullheaded and stubborn enough, and she is blessed by like tiny baby Jeebus himself. You let her figure it out. You let her figure out the entire terabyte. You give her no more help. Do not assist this woman. She does not want your help, sir. She continues to be a hard-headed dumbass instead of listening to people who might be smarter than her in this particular arena. So stop helping her. It's like throwing pearls among sows. It's just not going to help. She is a sow.
If it was a more narrow order.
Well, she knows what the link is, and she could just give it to us, and we asked for.
So they're going to run the Boudreaux trial immediately following the Charles trial. I thought it was the Boudreaux trial first and then the Charles trial later because they were going to need a bigger jury pool for the second trial. Let me look up which trial is first. And Google save us. Court TV says Lori Vallow Daybell told an Arizona judge on Tuesday that she's determined to stand trial for murder as planned on March 31st, even if her defense is not ready. Lori was sentenced to life in prison in Idaho for murdering her two youngest children, J.J. Vallow and Tylee Bryan, and conspiring to kill her fifth husband's first wife, Tammy Daybell. She's now in Arizona acting as her own attorney on charges of death of her fourth husband, Charles Vallow, and conspiring to attempt to kill her niece's ex-husband, Brandon Boudreaux. The two cases in Arizona are being tried separately, with Lori scheduled to stand trial for Vallow's murder first. Okay, I was wrong. For Vallow's murder first, beginning March 31st. Lori, so there you go. It looks like we're doing the murder trial first. Alrighty, so let's get back to this. This woman is a swamp hag donkey monster.
For her to do that, and
I wonder what Bing AI would do if I put in swamp hag donkey monster. I will try that later today and add it to the thumbnail.
What's that?
the attorney said no, she can't do that. She can't give you any.
What's that mitigator's name?
My mitigator's name, Pamela.
On your prior.
Pamela Kearney.
Do you know how do you spell Kearney?
Cerny.
All right, I'll make a specific reference to that.
And do we need an order, Your Honor, to pick up my husband's phone at Chandler Police so that Lonnie can do the extraction?
Well, you are.
Bitch, he was not your husband. You had him killed, allegedly, not adjudicatedly.
Already have that extraction in your discovery. What's the state's position on Lonnie Dworkin meeting someone at, you said Chandler, right? Chandler
Yes, at
Police
Chandler Police
Department to do another extraction.
Your Honor, obviously the state and defense have always had stipulations so that should something happen to the device while it's in the possession of Mr. Dworkin, that there are now no issues with chain of custody or anything else. So the state would have to draw up a release, have that scheduled on who it's going to be picking it up, have the defendant sign that release indicating that she understands that should anything happen to that she waives those rights to claim those things. So
I think what I was asking was, does Mr. Dworkin have the ability to just do the extraction on site?
on site where? At Chandler?
At Chandler.
I don't think the police departments allow anyone to go in there and conduct their work in the police department.
Okay. All right, so to maintain the chain of custody, the state can draw up an agreement, and if the defendant signs that agreement, then Mr. Dworkin could pick up that phone.
That's perfect. Logistically, how's that gonna happen?
She's gonna forward that to your investigator, and I guess he'll have to come down and have you sign it.
Okay.
All right. Be at recess.
Alrighty, and we are going to go straight into the other stream where I heard she got a bit spicy. Now, this is 6 days ago, but it seems that our Miss Lori Vallow got very snippy. I hope so, because, you know, she is righteous and she should be self-righteous about it. You know, I never saw someone with a moral high horse that had been, you know, cut off at the knees, but this is a very interesting thing to watch. I mean, you would think someone that is accused of, I don't know, triple homicide and coming up on, you know, another homicide and possibly an attempted homicide would be just a scotch humbled. But Lori, you are pulling off just, you know, holier than thou. And I cannot believe they found you competent. Dear Lord in heaven, I want whatever they were smoking.
Prejudicial publicity, which saturated the community to control disruptive influences in courtroom, deprived the defendant of a fair trial consistent with due process. So,
oh my God, is she going to go Sarah Boone? There are a cadre of conspirosities putting out lies, and every time you point your finger, you have 3 pointing at you. You are a terrible human being, Judge Wooten. Oh my gosh. Lori, you just have to read Sarah Boone's letters, and that is how you respond when you feel like you are being unfairly treated by the media, girlfriend. And true that, Lonnie Dorkin is a great name. No one puts Lonnie in the corner.
that and Arizona versus Cheney, which was the defendant is entitled to fair and impartial trial when publicity pervades court proceedings to the extent that the proceedings were prejudiced.
I told you they're like catnip for us women of a certain vintage. You get us a Highland mini cow, a little calf, we are going to be in heaven. We will just pet it and it's so fluffy. But we are not getting derailed. This is the Lori Hatchet-Face Vallow trial. And as Dodge Ram as our witness, we are going to get through it.
To the defendant. So obviously you read my objection, so I just wanted to add those on the record.
Okay.
Thank you.
Gregory Bentway, I know that she has a bunch of stuff that she's filed. I just need to fill out forms and, excuse me, this cushion is, the cushion factory, claimed that would help make me feel better, but I don't think it's working quite right, so maybe I have it backwards or something. That being said, I do need to get all of that pulled. I know it costs money and I have to get, a FOIA request and all that jazz. And I just have not had, it seems like a moment to do that yet. But be unafeared, because Sarah Boone is coming back. I know that she has 100 and like a super long transcript that just came out on her, case, her actual case. So I will look at that. I'm planning to do a Sarah Boone, update sometime this week, but I do need to get on all the family court stuff. I know several channels have done, big things about that and have all the paperwork, and they can, some people can screenshot and get all that, but I'll just go ahead and, pull it. I just haven't had a chance. Long story short, life is crazy with 6 kids, a chronic illness, and unexpected family loss. It's just, ooh, awesome sauce. I like that. So I guess Miss Vallow would not like any media to contaminate, contaminate, if you will, the jury.
Your prior attorneys had filed a series of objections to media coverage media being allowed in the courtroom, and I made a prior ruling that was filed back September 4th, which was fairly comprehensive. I am inclined to allow one pool camera. I'll issue an order with more detailed findings later today or tomorrow. But essentially, there won't be any media coverage during the jury selection process, and I'll put the reasons for that in the order.
Well, damn.
So that's, again, I'll issue a more detailed order later today or tomorrow. All right?
Your Honor, there's also the issue of whether Court TV will be allowed to live stream the trial. In other words, broadcast online in real time. Court TV would prefer to do that.
Are you able to, are they able to do a 1 or 2 minute delay?
Certainly, we can certainly do that. I just want to inform Your Honor, however, that when we share the footage with the pool, we can't delay that footage. So your order would need to require that all media receiving the feed delay it by, however long you wish to delay it.
And the camera, the pool camera would be simultaneously distributing that feed to whatever media requests it?
That's correct. We have the capability to distribute to up to 30 or 40 different media outlets, so we have plenty of bandwidth to do so.
It's prejudicial and it's going to be his fault.
All right.
But it's terrible for my case because everyone's going to know I'm not special. Oh, no, he meant go to the trial, I think.
Thank you.
Thank you.
All right. Let's get down to business on some of the.
Your Honor,
Yeah.
could I just add that we want to make sure that the camera's not going to be zooming in at any level to get to our notes and the things that are going to be on the table. I also previously, what has happened before is that they just have the camera on my face the entire trial. So I think when the judge is speaking, the judge needs to be on the camera. When the state is speaking, they need to be on camera. If we can add that to the order, I think.
All right. Well, my draft already includes that there'll be no zooming in on.
Lori, I would be happy to not see your face and have them put a rag doll with some puppet and a googly eye when you talk. Ma'am, I'm not going to be zooming in on your face. If I were in charge of that stuff, I would never want to zoom in on your face. Ma'am, I would just put a picture of Hatchet Face up with the little mouth moving whenever you got up to talkinate. Okay, so ma'am, no one wants to see your face. No one gives two rats' asses. Now I know you're going to be pulling the Kool-Aid out in the coffee grounds and the gel, but for the love of all that is crap spackle, no one gives a crap. And you should be telling them not to get the jury more than going on your notes.
Council table, anything on council table, or anything being handled, notes or that sort of thing being handled by any of the parties or the attorneys. As far as what they focus on, they'll be limited to focusing on the parties, myself, the witness, depending on the witness. I need to ask the state about that in a second, but they won't be allowed to broadcast any image of any juror. While I'm on that subject, let me ask the state, are you seeking any sort of protective order when a named victim testifies?
Not at this time, Your Honor.
Will you let me know if that changes?
Yes, I will.
Do you have do you have the names of your designated victim or victim representatives that might be testifying?
Kay Woodcock is a statutory legal victim and will be testifying.
Y'all, I thought OnlyFeeds was going to be more sexy, but ugh.
Is that the only one?
At this time, yes.
Okay,
For this trial, I should say.
for this trial, okay.
Oh, thanks. Ooh.
Let me ask this, are the parties ready to proceed around March 31st to April 1st?
Yes.
Yes, Your Honor.
All right, let me ask the
Okay,
state
so
next.
it's more of a back here.
Earlier
part.
during these
Okay, I
proceedings
can
and
do
past
that.
hearings,
That
you
looks-
indicated you thought the state's
well, just as
case in
stupid,
chief would
but-
take 2 weeks. You requested yesterday to screen for 6 weeks.
Your Honor, I did say 2 to 3 weeks.
Okay,
But I did say that while we had a defense attorney on and not Ms. Vallow herself. I am familiar with other pro per trials where generally the timelines are in excess of those with a defense attorney assigned. So in order to ensure that we aren't asking a jury later to stay longer than we pre-screen them, I believe it would be appropriate to screen them for 6 weeks.
so now that you're gearing up for trial and maybe you have a better idea, how long do you think your case in chief would take with a normal amount across?
Oh,
I know
no,
that's hard
Lord,
to estimate.
That still looks
And
stupid.
again, I would say 2 to 3 weeks.
3 weeks?
That would be at the outset of it.
Okay.
Probably, yeah, 2 to 3 weeks.
Okay. Let me ask advisory council, if we do an questionnaire, would you be assisting Ms. Daybell with your laptop in going through the answers that are received?
Yes, Your Honor. I mean, assuming we do all of that, because a lot of
Thanks.
times
I'm
the courts send us
trying to
back
get
to our
used to it 'cause
office
it's
to go through
her.
that. So if we do that here, then yes, of course, she's welcome to use our laptops.
All right. My plan is we can,
That looks like yarn. It looks like that's yarn on her finger. Ma'am, look, if Jesus knows that you and, Chad Dorkbell are married in holy craptimony, then I'm sure the rest of us don't need to be tortured with that thought.
do jury selection in the South Court Tower 5C. I know that the state has requested that the entire trial be held there. We can't do it. We can do jury selection there. I can give you rooms here for your victims and witnesses as need be that are outside this courtroom that we can have them stream in if you want, depending on, I guess, who the witness is or who's back there.
And obviously, Your Honor, I don't know if the public will be attending this or not. This also is a little different in that even in the mornings,
Ma'am, yes, the public will be attending. Sal, we're counting on you.
the jury is going to be potentially out here while the court is having morning calendar. If there's media out there as well, I'm just trying to protect the integrity of the trial by ensuring that the public, the media, are not interacting with witnesses at any time while they're out there. It's difficult when it's a very small hallway and very limited rooms to put them in. Obviously, I need a room for the victims that's separate from any witnesses.
Well, we have on this floor 6 rooms? 5 or 6 rooms throughout. We have 3 right behind this courtroom, and we can utilize them as need be to ensure that there's no improper contact between media or the public in general and any victims or witnesses. We can also ensure that the jurors don't have contact. If that means we bring them up in a separate elevator and have them assemble somewhere else, we can accomplish that. So my plan will be to do an questionnaire, remote questionnaire for the first 200 jurors. That questionnaire, I need to get a final joint pretrial statement with the list of witnesses to include the names of witnesses in that, but I'd like to send out a draft to everyone by the end of this week. bring up my calendar. We would probably send that out to the first 200 jurors around next Thursday, March.
So I'll approve it, but just remember, I'm your friend who might not be the best influence. So if I think it's a good idea and you think it's a good idea, we should probably get a third, more sane person to co-sign the idea before you do anything. But I say go for it.
March 20th. Yeah.
Because of the way they send this, the first day they can send it out the 24th.
Oh, I guess they can't send it out.
So we can do from the 24th to the morning of the 27th.
Okay, so we can send out that the 24th to the 27th, meaning it would be cut off on the 27th. The answers to those questionnaires would be emailed to the parties. That would give the parties the 28th, 29th, 30th, and 31st to go through those answers. We would meet on the morning of the 1st, discuss who needs to be let go based on those answers. Also on the morning of the 1st, a number of walk-in jurors that for whatever reason don't fill out the questionnaire in advance would come in to the jury room, the jury assembly room that morning and fill out the questionnaire. So that morning we'd also deal with those walk-in answers as best we can.
Who doesn't
Oh,
fill
that's
out
right.
their questionnaire
I
before
back
they
up.
come in?
The initial answers for
Terrible.
the remote, we're going to meet on the 31st. Let those people go. Whoever we don't let go will be told to report on the afternoon of the 1st. On the afternoon of the 1st, we'll be dealing with the walk-ins that come in the morning of the 1st. And the people that we haven't let go the afternoon of the 1st, that will be in person voir dire as needed. If we need to, which I anticipate we probably will, we'll do another 200 jurors on the 2nd. And if need be, we have another 100 jurors on the 3rd.
That next set of 200, that wouldn't be a remote question?
They
That'd
don't
be
have
regular.
I imagine that she has in her mind's eye the Yoda chair where he's floating on top of the chair in a lotus position. That's what I'm guessing that Lori thinks she looks like. She is a translated being and a goddess. So don't be mean to her.
Capability to do it remote. So we may have to, what'll happen is on the 1st, all those people, after they give their answers, will be randomized. The list will be re-randomized. As we proceed through the 2nd, those people get added onto the bottom of the list. So as soon as we get 12 jurors that qualify, that everyone's happy with, that don't have issues, plus probably 3 or 4 alternates. So as soon as we get to about 15 or 16, we're pretty much done with jury selection. So we don't have to necessarily question all 200 of those people. We can do panels of 20 or something like that. I anticipate losing quite a large number of people just based on prior media coverage and people already having some sort of opinion about the case. I
have
normally
all the
wouldn't
opinions.
include a defendant's name in the e-questionnaire that goes out remotely, but on this case, I'm inclined to, just because that's what we want to know. We want to know if people have heard about the defendant and whether or not they've heard about, or if they've formed an opinion about her or this case prior to that. Does anyone have an issue with that, State?
No, Your Honor, I think that that's a good idea. That's going to be at least one of the initial reasons to strike a lot of jurors.
And Lori's going to have a bitch fit about this. Why? I'm just guessing. I haven't seen this. I'm not Miss Cleo, so I don't know. But I'm guessing Lori's going to, waffle about a lot and then disagree because it's prejudicial.
My only issue with it, Your Honor, is that it could be bad both ways, right? If you put the name in there, if you don't put the name in there. It's been my experience that people will say they haven't heard when they know who that really is. And there's people that will want to be on this jury just for this purpose.
People would lie?
Well,
It's going to be complicated.
all the research indicates that these e-questionnaires, people are more likely to give honest, candid answers than if they're in a group of people and they feel sort of that peer pressure of what's a good answer and what's a bad answer. Your name's going to come up sooner or later, so I would prefer to just get it out in front of the potential jurors to begin with. My e-questionnaire is going to be fairly basic. It's going to focus on qualifications, the charges, the witnesses, and then obviously whether they have an opinion about you or this case. For the people that make it past that level, we'll question them more thoroughly in person.
And like you were saying,
Yeah, I mean, how many times can a person say, look, in my other murder trials, I have been made aware that people are liars? I don't know that I would put that on your resume, Lori, but hey, I'm not going to tell you how to be, a translated being. You don't tell me how to be Mo, we'll be good.
as far as group kind of voir dire, in my experience, we went through 1,900 jurors in my last trial, so it would be good to do individual voir dire if we can, than group voir dire, because they learn things just in the voir dire and it disqualifies a lot of jurors.
I'm not opposed to that, but that's going to be sort of a day of play it by ear sort of situation, whether we do small panels or just go a single person. If we go single person, our jury selection could extend into the next week. But if we're able to seat a jury, I would expect opening statements on April 7th.
I guess they do.
Somewhere around there. Does the state indicated, I have it, there was just one day in April that you wanted to go a half day?
Correct, Your Honor. The 24th.
All right. When can you file some sort of pretrial statement that sets forth all your potential witnesses and a statement of the facts?
Probably by Thursday.
All right. Does the state anticipate any presentation of autopsy photos or crime scene photos? In other words, I'm trying to gauge, I would usually put in a question about jurors may be required to view evidence that shows wounds or that sort of thing. Is there anyone that's unwilling to look at this type of evidence?
Yes, Your Honor. We will have both, obviously, with self-defense trajectory, and those injuries are very relevant.
Okay, so I will include a question about that type of evidence. Sometimes jurors don't want to look at that type of evidence, so. All right, any questions or concerns about our jury selection, the proposed trial dates from the state?
No, Your Honor.
Just so I have it clear, Your Honor, we're going to start on the 31st with jury selection? Is that
We'll
correct?
be meeting on the 31st, and then actual dealing with in-person jurors on the 1st, 2nd, 3rd.
Okay.
Robert and I.
Let me ask advisory council, are there any dates that advisory council would need to be dark?
I am fine for April. I didn't hear back from Robert. I would think.
Please let us know, because in that e-questionnaire, I'm going to put in a proposed schedule.
Kevin, I believe that was from the Idaho trial. So that was a double or I'm sorry, a triple murder case. So they had a lot more people. It did also involve children. So I think that this case, as sad as it is, because it deals with an adult, I don't think they're going to have as many people that have vehement, feelings about this. You're going to find a lot of people that have been exposed to this case because Lori Vallow is a name in true crime. It is what it is. But I don't think that you're going to have the visceral level of hate that this woman had for the, because she had unalived her own children. I think it's bad enough that she unalived Charles or had a part in it, but I think that it will be easier for her to find a jury in this particular trial, in the other trial.
Well, I don't know that I'm going to screen for a full 6 weeks based on the state's anticipated presentation, maybe 5 weeks. So into let us know the schedule into the first week or two of May.
As soon as I get an answer from him, I'll email your judicial assistant.
All right.
And one more time, Your Honor, so the remote question is going out on a.
It does kind of seem like Lori Vallow specifically got a larger, tunic prison scrub so that you could see her little bra strap. Well, isn't she smexy? Doesn't Chad want to see her bra strap? I mean, for his burning loin fire. You are a gross human being, Lori. No one wants to see you. Ain't no one want to look at you or your bra strap that's a dingy damn orange.
March 24th, all answers have to be back by the 27th, so we will get them on the 27th, or,
You'll either get them late the 27th or first thing the 28th.
Okay.
In the morning, late in the morning of the 27th.
Oh, okay.
okay.
You should get them some point on the 27th.
Just so we can plan, because it sounds like we'll just go out to Estrella and go through these.
Yeah, they're closing it at like 8 a.m. on the 27th.
You'll have to have a internet connection.
Yeah,
out
we
there.
can use
Okay.
our laptops out there,
Okay.
because you want to be ready to discuss everything on March 31st.
Yeah, and if the parties have an obvious, there's some jurors that are going to be obvious that need to be let go. If you're ready for that, that's always helpful. I know it's a little bit more difficult with pro per defendant in consulting like that. All right, let me get to.
So we'll come out on Friday and go through the questionnaire. We don't get any questions on that.
All right, the defendant had filed 2 separate motions for specific discovery. The first dealt with communication between the assigned deputy county attorney and law enforcement agencies. I've read and the second one was, well, let's deal with the first one. I've read the response from the state. Basically, your response is you have disclosed all those communications. There are no other communications.
Correct, Your Honor.
All right. So let me ask the defendant.
Yeah, we received 6 email communications, and they were in a short time frame, not the full time frame. And it seems to me that in the last email ends in kind of a question that was probably answered, and then there's like no more communication. So it doesn't make sense that there's no more. We asked for all of them if they could be provided to us. We don't understand why.
Eon Dub, this is Lori Vallow Daybell. I do call her Dark Bell. I do not Daybell her. This is the famous cult mom, the Doomsday Mom. She is probably more infamous for the unaliving of her 2 precious children, Tylee Ryan and JJ Vallow, also being a part of, Chad Daybell's wife, Tammy's conspiracy to murder. This particular trial is happening in Arizona. She was adjudicated guilty on all of those charges in Idaho. She has now been taken to Arizona because she is suspected or accused of having a part in conspiring to kill her fourth husband, Charles Vallow, with her brother and Chad Daybell, but mostly with her brother Alex Cox, who is now dead. However, at the time of Charles Vallow's death, it was sort of ruled as a self-defense kind of thing. There was kind of a speculation after Lori got charged in Idaho whether Arizona was going to even bring this case and the attempted murder of her niece's ex-husband, Brandon Boudreaux, if they were going to bring these charges forward. But they are. Lori, when she was found competent in this particular, court, decided that she was going to represent herself. So she is pro se, and this is what we're looking at. It will be run in 2 trials. So the first trial is going to be the Charles Vallow murder trial, and then you're going to have the attempted murder of Brandon Boudreaux. And no, I would never do that to you guys.
They're not being provided to us, and what the state is possibly hiding at this point, and they can't just turn it over so that we can go through them. It's been, long over a month since we filed that motion, so we would just like them to please turn over whatever they have left.
All right, and I'll ask the deputy county attorney. I imagine some communications are by phone, so in other words, we're not captured.
Correct, Your Honor.
All right, based on the state's avowal, I don't know, I can't tell them to turn over something they say they don't have, so. I'll find that the state, based on their avowal, and officers of the court have complied with the request. The second one is a little more, I wanted to get clarification on. That was defendant's request for video interviews, but it seemed like based on the state's response that there was some confusion about what was a interview recorded in an interrogation room situation versus a body cam. Did the state's response provide clarification to you?
No. So the body cams were turned over, and they're in like 12-minute increments. There's like 4 different body cams. This was a full 2-hour video that was released by Gilbert Police to the public, and it's online. So I would like that video of the interrogation room, the full 2-hour one, to be turned over to the defense.
You ridiculous numpty, you have it. It's in Discovery, or you can go on Flippin' Flapjack YouTube. Ma'am, it's not our fault that you have 2 terabytes or 22 terabytes of information, and your ridiculous behind decided, because Ezekiel and Moroni just, came down from the heavens to tell you that you ought to represent yourself. That is not an us problem. That is a you problem. Maybe you should go talk to your own personal angel about how he's, sent you down the wrong path.
All right, so do you know what that is?
Your Honor, based upon the defendant's reply, she's requesting a video interview from the 31st. Those are on body cam and were turned over to the defense. We have requested everything from, I think that one was from actually the Gilbert Police Department. A lot of these overlap. So I am not sure what the defendant is.
Who was the person being interviewed? And you said the 2-hour interrogation that Gilbert released.
So it's myself and my daughter, Tylee Ryan, and Melanie Gibb.
Okay, you know what? We might tonight.
And is that
we
in a-
might watch that to see what's going on. She just annoys the ever living poop crap out of me. Not gonna lie. So her little girly girl and squishing all around and showing her boobies and like trying to be all giggly after she, literally just saw the man that she promised to, love and honor and cherish. And I know some of those vows are mixed up between the man and the woman, but I just, chose to follow most of them. The man that she'd promised to spend the rest of her life with, just got shot and she's all giggly and talking about a pool party. Yeah, it's annoying as all live and get out. And I bet you 27 cents that that was in her damn discovery that she's been too damn lazy to figure out how to find.
Interrogation type room?
Yeah, it was at the Gilbert Police Station, and I didn't realize we were being filmed that whole time. I didn't know we were being filmed, but we were being filmed in that room.
You giant ridiculous moron, have you not seen anything from CSI or Law and Crime Special Victims Unit? I cannot with you, woman. I didn't know we were being filmed. Are you in a police station? Then you're being filmed. I did not know I had to tell this woman, but you twat waffle.
Room.
And are you familiar with a video in a room?
Yes, that's what we have disclosed, is an interview of, it is
And you're saying you don't have it?
defendant, her daughter, and another.
And you're saying you haven't gotten that?
They have given 4 about 12-minute body cam videos of the policemen's body cams that were in the room with us, and they go in and out of the room at different times. So there's different body cams. They're all mixed up. It's not the full entire one. And my understanding is that the full entire 2-hour interrogation room video from the ceiling is available online, but I don't have it in Discovery.
Correct. That's what I'm trying to clarify. So did the state disclose not a body cam, but an interrogation from up in the corner of a room vantage point?
We disclosed a lot. Let me see if I can find out. We did. Yes, my paralegal is present here as well, and she has advised that we did. Your Honor, we disclosed over.
Can your
Where is
paralegal
it?
provide a Bates number or something so that maybe the defense just has overlooked it?
Let me see if we can find the actual
Or maybe the discovery notice.
discovery letter.
Okay.
Well, at that point, she wouldn't have been Mirandized because she was considered a witness. If the police were going to go after anyone at that point, it would have been Alex Cox because he was the one that pulled the trigger, so to speak. So at that point, they kind of saw that there was something a little, but of course she will. She has done more to silence Tylee Ryan than I ever thought possible for a woman who claims she was a mother. Oh, someone learned to use the mute button. Good idea. This is going to be fabulous.
Your Honor, all we do have is the 4 body cam. We can ask again and see if they have a overall.
Are you getting this? Have you seen this, or someone told you that there's this video?
My mitigator showed me part of that video, yes, with my previous team. That's how I know about it, otherwise I wouldn't know about it. She said, do you know this is online? I didn't have any idea.
And you're sure it's the Gilbert PD on that date?
Correct.
All right, I'll ask the state to follow up with Gilbert on that.
We will, Your Honor.
There, if that is out there, obviously it should have been disclosed. All right, remind me to follow up on that next time we are together. Next, I have a motion limine, 2 motions in limine, one regarding Alex Cox statements and one regarding Tylee Ryan's statements. All right, so let me ask the defendant, generally any hearsay is defined as any out-of-court statement offered for the truth of the matter asserted. The state is referencing what are definitely out-of-court statements. Obviously, there's some exceptions to the hearsay rule, and there are other things that are characterized as non-hearsay. So how do you think, let's first talk about Alex Cox. How do you think the statements fit into your, either one of those exceptions or non-hearsay?
I feel like the state is blanketing that whole thing, and obviously it's like a case-by-case basis, right, on these statements. So there is the police interview of Alex
wait, you
Cox
guys.
that I did.
I've got to get my smart glasses on, just like Lori, because it's like a blanket thing and such, and it's real mean to me. But let me get my smart glasses, because maybe that's how she does it. All right. I am worried. I think I might have to call the hotel. I think I left my real sparkly glasses up in, up at the hotel. Mr. Mo will never let me live it down, because I promised him that I looked at everything and I checked everything over, and we had everything. So just between you, me, and the internet, I didn't lose my glasses.
Did not think falls under hearsay.
Why not?
Yes.
Why does it not fall under hearsay?
Yeah.
Because we're not using it for the truth of the matter asserted. We're using it in corroboration of the circumstances. Everyone came in and told their same story that corroborates different facts in there, not for the whole truth of the matter.
Aren't you arguing that what he said was true?
I can't say whether another person says that it's true or not, but I'm saying what he said and what my daughter said and what I said in those 3 police interviews determined what the police said, how the police acted, what they did after that, their next steps, how they treated the entire case like it was self-defense. All of those are relevant to the defense that it was self-defense. So, yes, I think they're for that purpose. But I also think that Alex's statements also have a lot of the exceptions apply. 803, 804, there's a lot of exceptions that also apply to some of his statements and not all of his statements.
Such as what? Which statements do you think?
Yeah, you should have
apply
specifics.
to.
There should be
Specifically,
specificity.
his statements made on body cam to police in the driveway, specifically his.
I don't know what the statements are, so that's what I'm asking. What specific statements do you think?
You should have had quotes ready, Lori. I know if you had been a real lawyer, it's a real pickle, when you don't know this legal stuff. It makes you kind of look like a dumbass, doesn't it?
Are allowed to come in under the rules of evidence?
I think under 8031, the present sense impression is his statements made to police officers at the house.
A present sense impression is where you're actually observing something and you're talking about it as you see it happen. So isn't he saying, again, I don't know what the statements are, but is he saying what happened prior? Or is he saying
Yes,
something that
prior.
he's, okay,
Correct,
so it's not a
prior.
present sense impression.
Okay.
What else?
Then I think it falls under 803.2, excited utterance. He was under the stress of the whole situation when he made those statements.
What was his demeanor when he made those statements?
Calm as fuck.
Upset.
What's the specific statement?
I shot my
All of it?
brother-in-law in self-defense. I got hit in the head with a bat. There was an altercation. I don't know what all the statements are, but
How long after the incident did he make these statements?
immediately after, as far as I know.
Oh, bless her heart. Bless her heart. Oh, thank you for that info, Northwest. And actually, that was one of the high schools I went to. She is Sarah Boone on holy retard level. Yeah, it looks like she's doing one of these things. She's like, look, I'm wearing a bra. I mean, okay, ma'am. I mean, it's a look. Would you? Oh, I got a bra. Well, most of us who have boobs generally wear bras. I don't know why you're trying to smexify yourself up, but ew. Just ew. Yeah. Yeah. Look, all of them are excited utterances. Well, except that you say that they also corroborate, your case that it was self-defense. So you want those removed when he is clearly excited utterancing, that it was self-defense. It seems kind of dumb in your self-defense case to, rule an emotion in limine to preclude the one statement that says, I unalived him because he hit me.
No.
Well, immediately to some people means 2 seconds, to other people it means 30 minutes. Tell me what immediately means to you.
As soon as the police arrived.
I don't know did they arrive 30 minutes after the incident? 10 minutes, an hour?
I was not there. I do not know what time they arrived.
All right. So you're asserting excited utterance. Some of these statements come in. What else?
803.3, the mental, emotional, and physical condition, because it shows his state of mind, which was scared at the time.
Scared. Okay, this is some BS. Now, Charles Vallow played minor league baseball. Now, the cockamamie fakakta story that Lori and Alex, dreamed up in their peyote wonderland trips was that Charles, swung a bat so hard in Alex Cox's head that, he was just discombobulated and scared for his life. So he went and he got himself his sidearm because he keeps it in his room when he's with the children because he doesn't want anyone getting into his sidearm. But in between Charles Vallow, who is on the attack, manic with rage, now, somehow he managed to, get him with a bat, but Charles then stops his attack and waits in NPC, Mortal Kombat mode until, Alex can run to his room and get his force multiplier. And that's he's doing that. Well, then he comes back and then Charles is back in attack mode and it's, time to get serious. So he shot him, I believe, several times. Now, no one believes this story. Now, Alex did try to show a very small little scritch on the back of his head, but it's a little sus and a whole lot of sus, and then triple sus when, suddenly her husband passes, accidentally, and then Charles Dorkbell's wife passes, accidentally, and then they suddenly get married. Yeah. One was when Charles was lying flat on the ground. That is not self-defense. He is no longer an imminent threat. You can leave, you can flee. Now, I don't know if Arizona has a duty to retreat, but when someone is on the ground, they are no longer a threat, especially if he wasn't moving.
Any others?
Yes. 8035B, the recorded recollection. I know that in the state's,
This heifer is just pulling out numbers and letters. This bitch has no idea what she's talking about. And look, this is not the pot calling the kettle black, because my ridiculous, redonkulous butt, even me, the person who is semi-silly person on the interwebs, would not be pro se. So I can safely say that I am better than Lori Vallow because I would have attorneys. But I wouldn't be in prison for all of this. And of course, all of these people, up to and including Alex, Cox, are no longer here to dispute any of this. Tylee Ryan is conveniently not here.
in the state's reply to my response, they did not think that 805 applied because A, B, and C, but I did not see an and after A, so my assumption was that B and C, since there's an and after B, were what needed to be put together. So B was made or adopted by this.
KLF, I also think that there was a facet of that Chad was not a fan of this very close, almost creepily close sister-brother relationship that Lori and Alex had. Now, if you are Chad Daybell, you want to be the first person in Lori's life. You are a translated being. You are God's chosen one. You have picked this woman out of the many women who you tried this line on, and she actually bought it. So I think that Chad Daybell would not approve of this, close relationship between brother and sister. And I think you're right. Once Alex had served his purpose, Lori's attention didn't need to be divided. If you notice, every single, death seemed to really, really take Lori's, ancillary focuses away. Charles first, and then Tylee, and then JJ. Things that were taking her away from Charles didn't seem to last, if you notice.
Witness when the matter was fresh in the witness's memory and accurately reflects the witness's knowledge. So I felt like 803B, 5B, the recorded recollection of his police interview and the body cam footage applies under that exception.
All right.
And I'm going to stop you right there because you started this entire spew of numbers and letters with "I think." And, ma'am, I X'd out.
Generally, 8035 is a recorded recollection, meaning it's something they wrote down, or maybe they recorded their voice saying something. Let me ask the state to respond. We're just talking about the Alex Cox statements.
Your Honor,
Maybe I should start with, does the state
I will say that I think Alex had a kind of rough life too. So while it does feed my inner conspiracy theory, I do know that, there were blood clots. There are certain things that you can do to induce that a little bit more. Well, or if someone has a family history of it. But I do think that Alex engaged in behaviors that were, going to increase the likelihood of that. That being said, if I don't hear Black's Law Dictionary fairly soon, I'm going to be really upset. And Lori hasn't asked if this was, an admiralty court. I feel like she's really missing the bar by, not bringing out the sovereign sit stuff.
intend on introducing any statements from Alex Cox?
Your Honor, I haven't decided if we will at this point. I can say with 100% certainty, we will not be admitting his interview by police that was done at after 10 o'clock in the morning. We don't,
Are you referencing what time he was interviewed versus the time of the incident?
let me say it this way. So the state has laid out in its motion the timeline. So that is actually in our motion. We show that when
8:30 a.m.
is when the
roughly.
911 call was made. So we have soon after that, the police arrived and there's body cam video from that interview. Then Alex Cox is later brought to the police station and there is a in-depth interview with detectives at a little after 10 o'clock in the morning.
So you may or may not be attempting to introduce statements at or around the time that the police responded?
Correct, Your Honor. If we do, those would be brought in as co-conspirator statements against a party interest. So obviously the state can bring in statements that are hearsay against a party.
Right. But I guess, is the state intending on introducing any statements of Tylee?
No, Your Honor. Kylie made no statements at the scene other than giving her general biographical information on body cam. Her entire statements were made at the police station, again, after 10 in the morning.
All right. So on your response as it relates to Tylee, you say, again, present sense impression. I don't think it's a present sense impression. You also argue excited utterance. What else?
8033, which is mental, emotional, and physical condition with the same thing, her state of mind, then
Her
being
state of
scared.
mind.
And also,
You unrelenting cunt tornado. Ma'am, her state of mind, she was scared. I wonder how fucking scared she was when your dork bell of a husband led her out to a field with her uncle that she thought loved her. I cannot. The absolute audacity. Bitch, it must have been on clearance. How fucking dare you talk about your daughter being scared? Ugh. You are going to be so lucky to get a jury because the absolute just hurricane of smug and ugly that you have in your soul, I couldn't even stand near it without calling you a twat waffle in 10 seconds. So God bless anyone that can.
8043, statement against interest. They use that statement in the indictment where Tylee says that Charles says, if you hit me with that bat, you're going to jail. That's the part where she's nervous in her interview saying she's scared to tell the police that she's the one that brought in the bat. So state of mind and the statement against interest both apply to Tylee's
All right.
police interview.
Come on, Judge. Tell her how stupid she is. I need it. Because
All right. Anything
her-
else? Does the state want to be heard further on that?
Your Honor, the only
And y'all, I'm sorry. I generally don't say like, super duper curse words, but that just was like ants all over my spine. I am sorry. But the fact that this woman is going to sanctimoniously sit here and talk about her daughter being scared, when she allegedly, but in my opinion, killed her fourth husband, who generously opened his heart to Tylee. Yes, I know Tylee was pissed off at him at the time because she was with her mother, who was absolutely and, ridiculous. But I don't know. The fact that she was worried about her daughter's scaredness when we know how Tylee ended up and how scared that little girl must have been. And yes, I know she was, an older teen, but she was a little girl, because I can't imagine when you're that scared, you don't turn into a little girl. I know I would. So this heifer is just, there is not a place far enough in Hades that she could go.
further thing, I think that
An orange-clad twatacuntopus. I like that. I might still twat a cuntapus. That is a good one.
The state will bring in is that obviously the defendant has been found guilty of killing both Tylee, other individuals, but in this case, the defendant cannot benefit from killing a witness and then later try to bring in their statements for their benefit. So in addition to none of her statements being admissible under the rules of evidence, as any of the exceptions that the defendant has done, we also believe that it would be.
Bitch, you been denied. No one cares what you say, 'cause you are dumb and you don't need and you don't have a lawyer, but bitch, you been denied. Bitch, you been denied. Finally, a blonde female attorney I can get behind that doesn't have an HR voice.
Be improper for her to
Whoop, whoop.
be allowed to bring them in under that theory.
In other words, there's been a judicial finding that the reason Tylee's unavailable as a witness is because of the defendant's actions.
Correct, Your Honor. There has been a jury trial and she has been convicted of that.
All right. All right, the court,
Kinda sucks, don't it, when you kill your witnesses? I don't know. I tend to not do that, but I don't know. Better luck next time. It's a good thing Jesus loves you, because everyone else thinks you're a cunt cannoli, but you got Jeebus.
is on a preliminary basis precluding references to Tylee Ryan's statements, any statement made by Tylee Ryan. If there's some reason where a door might be open to any of those statements coming in, the defendant's requested to make a request outside the presence of the jury regarding that, and we'll deal with that outside the presence of the jury. On Alex Cox,
that I've
I think that's
seen.
probably going to be more of a statement by statement basis. But I'm skeptical of any statements coming in hours after the initial police response. I think we'll deal with what statements may or may not come in when the police first arrived on scene and or the 911 at the time that they're attempted to be introduced.
But I do know, y'all, Lily's musing, there is a bright, light on that that nuclear dumpster cloud. If Jeebus ever comes back, we know to find him in prison because he's always hiding in there. So if Jesus decides to play hide and seek when he comes back, we know to find him just in prisons. That's where apparently he likes to hide. So I will be doing my final thoughts. I am getting clips that I want to pull up, but ugh.
All right, I also received yesterday state's notice of disclosure and request for disclosure. Did you get a copy of that?
No,
You haven't seen that yet?
no.
I'm sorry, the
State's notice of disclosure and request for disclosure. I didn't realize. It was actually filed in January, so you should have seen that. I misspoke when I said I got it yesterday. It was filed January 16th. Have you seen that?
I'm looking it up.
What are we? Dates
I
disclosure?
think the court may have ruled on that one, Your Honor.
Well, I don't think I ruled on, at the very end, you're requesting, she submit to fingerprints, palm print, footprint.
Oh, that's, okay. I think that was prior, yes, significantly. So that would be to tie her to any of her.
Is that for other conviction purposes?
Correct, yes.
All right. And when did you want to do that?
If we are going to be here on the 18th, we can take them then.
I don't know that we need to be here on the 18th.
And obviously, I was unaware we were going to set this because we set it
Right.
just recently, so. I don't know if we can keep that on just to take that.
Okay, what about the state, you requested copies of any recorded statements made during interviews conducted outside of your presence? Is there any of those, were there any interviews conducted by you or your team? Of
So
any,
far?
were there any interviews conducted of any witnesses out by you or your team that you're aware of?
So far, not that I'm aware of.
All right. Do you plan on calling any experts to testify?
We do plan on calling one expert.
Who's that? Has it been disclosed to the state?
We are, yes, we're working on that today as an addendum to the
Who's that?
witness list that, Lonnie Dworkin.
All right.
Bonnie Dworkin.
That's your investigator?
No, my investigator, Jeff White.
Oh.
That's the expert.
What kind of expert is Lonnie Dworkin?
Phone and digital.
I think I remember his name. Are you aware of that?
No, Your Honor.
All right, expert reports and disclosures are due 30 days before trial generally under the rules, so if you're planning on using that witness, you need to get that disclosed right away, and I may have to take that up depending on what the state's position is. But at this
Your Honor,
point,
that-
it's technically late.
Maybe another reason to be here on the 18th. Obviously, if that's disclosed this week, we can potentially address that issue on the 18th.
All right. Let me ask the defendant, do you have a position on the taking of prints and photographs? Generally, identification type things are permitted over any defendant objections. So do you have a record you want to make on that?
Not really.
All right, I don't see any
For
reason
what
why.
purpose? I don't understand.
In the event that you're convicted, it may be used to prove other convictions. That reminds me, is the state planning on proceeding in the second trial regardless of what happens in the first trial?
I believe so, yes, Your Honor.
And how much time would you need between the conclusion of the first trial and the start of the second trial?
Your Honor, I would say at least 30 days since we do need to actually subpoena out-of-state witnesses for the second trial.
I'm wondering if it wouldn't benefit everyone to go ahead and set that, a provisional second trial date
I still think it
now.
would be cool.
That's fine, Your Honor.
May 11th is still my last day.
Is that second trial,
Right.
how long do you think it would take the state to
Probably
present?
about 3 weeks as well.
Similar?
I'm not gonna- Your Honor, I'd like to remind the court that the last day is May 11th. Oh, yeah, there's that rule.
Well, I'll probably exclude some time based on the fact that you can't do two trials at once.
The state could combine the trials and do two trials at once, but they don't want to do two trials at once, so it really violates my speedy trial rights if they do not give me a speedy trial by May 11th for both cases.
Well, in that,
Not to mention
And
that
she told
they
them.
did combine all the discovery into one case. They didn't give me two different separate discoveries for two different cases, which would be much more convenient considering the voluminous amount of discovery that they piled onto us.
it's almost like there's these people who understand discovery and can make a case out of all this stuff and all this paperwork. Now, I can't relate rightly at this moment what they're called, but there are people like that. I would use the yellow pages. But I do agree that one trial is better than two, but if it pisses Lori off, I'm sticking with two trials.
Does the state want to do, combine both cases?
Your Honor, if the court gave us a little time to work it out and the defendant wants to join them, I mean, obviously,
I don't know that,
the normal defense attorney, and I don't mean that in any way, normally they would be severed.
severed because you
Due
don't
to-
want one jury to know about the other
Correct.
two separate charges and have a harmful rub-off effect of the evidence in one case affecting the evidence in another case.
Correct, Your Honor. That's why they were filed separately. But if the defendant wants them together, the state would have to request this be pushed back slightly so that we could then get all the witnesses for that trial together, since they were not subpoenaed for this trial. But if that's what the defendant wants to join them, and she understands that prejudice and that she's then going to be waiving that prejudice with that, then the state is certainly willing to do that. But we would then have to request to have that trial, or this trial date, moved back to allow us to get the other witnesses lined up.
Her associate counsel over there is like, Heifer, they are trying to help you. Do not do this. And she's like, I have been derogated toward. This woman said I wasn't a normal defense attorney. I mean, just the fact that I'm wearing handcuffs and, you know, ankle cuffs. I mean, she is derogated.
That was not, yeah, that's not what I was saying, it's to combine them. I'm just saying, give me my second trial by May 11th. So
Right.
the court can figure that out.
All right, well, I'm going to waive some time on that second trial over the defendant's objection. Primarily, again, the defendant can't try both cases at the same time. Secondly, I'm not sure how much actual prejudice there is with the time violation in the sense that you wouldn't be released from custody anyway.
Yeah, it's not like you're
And
going
thirdly,
to the mall.
the rule for time violations under Rule 8, I think it's 8.6 is that any
JKD Buck, that's what I said. I was like, why is Trey Gowdy here? I thought he was from North Carolina. Or not here. I didn't think he was from Arizona. I could be wrong.
violation should be a dismissal without prejudice unless there's an actual prejudice shown, in which case the state could just refile the charge. Regardless, I think some time is warranted to be excluded because primarily you can't try two cases at once. What if we set a start date for May 12th? I realize that's could potentially be a quick turnaround, but again, I don't think this case is going to take 6 weeks.
Your Honor,
We can adjust that as necessary.
I, again, am going to ask for a longer time. I believe this will go through the beginning of May, and to have the state try to get those witnesses lined up and subpoenaed while in trial, I don't believe is.
Well, if I push it out any further, the parties need to be aware that I won't be trying the case. I don't think I would be anyway. I'm rotating at the end of June. And given some of the trainings I have to attend in June, I don't think we could get it done.
Well, both parties could send out subpoenas now for that second date for May 12th, correct?
Well, that's assuming we're done by about May 1st, probably, in this case, the first case.
And then, Your Honor, I did indicate that the state needs to be dark in May, the 21st, 22nd, and 23rd.
You said 21, 22, 23.
Correct.
Of May?
And I would need to be dark the 19th, 20th, and 21st as well, so.
So given that we would be dark that entire week anyways, it really doesn't make a whole lot of sense to.
All right, sorry to interrupt. Let me speak with the criminal presiding judge about scheduling the second trial. We can discuss it on the 18th. Let's keep the 18th, but let's move it to later in the morning. Actually, let's move it up. All we're going to do is discuss a couple matters, and then there's no reason for the fingerprinting and stuff to be broadcast or on video, so I'll prohibit that from being recorded or otherwise broadcast.
How stupid is she? Like 1 to 10, 10 being someone who would slap a hungry lion in the balls with a tennis racket while covered in pork chop gravy. I don't think she has the pork chop gravy on her. But that being said, anyone who is going to represent themselves in a first-degree murder, conspiracy to murder trial, not smart. Yeah, and I don't think the judge realizes dark, but I do think that is common parlance for they can't be in trial. So it is a bit brazen, but you know, I'm going to tell you right now, if Chad Dorkbell didn't mark me as super dark, I would find it a life achievement not unlocked. I want that man to think I am obsidian, because I think he is dork idiotson. So please, Mr. Dorkbell, come at me.
So have your person here. Let's do that at 8:15 a.m. on March 18th. And then we'll also discuss whether the defense is disclosing Lonnie Dworkin as a witness and whether or not he has a expert report prepared and disclosed at that time.
Yes, as of right now, Lori, I don't think her expert, who is an expert in cell phone data, has even gotten the phone at this point, and the state has yet to receive any sort of report from her so-called expert. Now, typically those reports, as you heard the judge say, were supposed to be in 30 days prior to the trial starting. And who let Dworkin continue to be a name? And true that.
I will have the questionnaire for you by then, so you can review it. Anything else we need to discuss that I've forgotten about from the state's perspective?
Your Honor, I showed two other motions that the defense filed that I did not see rulings on by the court. They were both motions to dismiss. One of them only related to the 2022 case, I think. No, I'm sorry. Both of them related to both.
What's the filing date?
January 14th for one of them. It was an 8.2 speedy trial one. And February 4th, which was an extradition rule 8.3.
Of February 4th? Okay, so the motion to dismiss CR 2022-0.
Thank you, Northwest, for that. I wondered where we had heard him before, but I knew we'd heard that name because it's not a name that you don't hear it. Or you hear a lot.
001242 for lack of speedy trial, I ruled on January 24th.
Okay.
That minute entry was filed January 24th, and then the motion.
That just seemed to get.
Was that the motion to dismiss CR 2021 and 001704 and the other for violation of Speedy Trial Act.
Correct.
That was ruled on February 25th, so last week,
Okay.
a week ago. Anything else from the state?
No, Your Honor.
Anything else from the defendant?
Yes, Your Honor, I have one kind of housekeeping matter that I wanted to ask you about. I know that MCSO has some security restraints, the things that I have to wear during trial, and
I meant to
I wanted to ask about that as far as, am I going to be able to stand at the podium to talk to witnesses, to question my witnesses and to cross-examine, or am I going to be able to move about with the leg thing and the shock vest and all that?
you're going to stick to your table and you can go to the podium. Okay?
Okay.
When you're giving your opening statement and closing argument, you'll stay by the podium.
Okay,
And if you need to hand a witness an exhibit, your advice.
I'm just imagining Lori's opening statement. Like, you guys, it's just totally icky, but these people are saying I murdered my husband. I mean, well, he was like my fourth husband, but because my fifth husband is very close friends with Jeebus, have you heard the good news of Jeebus? That would be really, really awesome if you found this to be like self-defense, because that's what I told my brother to say. Anywho, if you would like to hear the good news. Oh, dear God. Actually, it's going to be like this. So you guys, I am not the Lori Vallow that you know on television. I am the Lori Vallow with the Disney princess voice. And I really like, everything ending in an uptone. And I will be talking to you like a, Snow White that's done ketamine. I have little forest creatures help me with my things at the prison. I'm really a sweet person, and even Jesus says so. You do have to ask him, but he is my BFF, so great.
Advisory council will do that.
okay. Or my paralegal can do that too. or-
Is your paralegal going to be present here, designated as your? I guess they can be present. I'd prefer advisory council to be the one that approaches witnesses if you need to hand an exhibit or something like that.
Okay, so I'm going to be standing there, and if she's sitting here, she's going to come get something from me and go walk it over to the witness and then come back?
Correct.
Just the logistics of it? Just
Yeah,
fine.
and there'll be a table or a cart here that'll have all the exhibits on it within reach of the podium. So,
Okay.
anything else?
Your Honor, do you use case lines for exhibits?
No.
Thank you.
I think they're still working out the bugs on that. So,
Do we need to have our exhibits in place?
all right, we'll see you at 8:15 on March 18.
So she can mark them.
Be at recess on this matter.
It's usually like a day or two.
Carolina Hernando, from your type to God's ears, I swear. Well, is she going to have a glam squad? I mean, I'm surprised if we are going full Boone, if we are going full Sarah Boone, why she has not yet asked, oh my gosh, dear Lord, asked for, her glam squad. I mean, how is she going to look Disney princess, with coffee grounds Kool-Aid? I mean, this garish shade of orange was, something I picked because I figured what would look like you could do it in prison. Yeah, y'all, I'm honest. I asked Mr. Moe, I was like, of these colors, what looks like you would do it in prison? Well, she didn't get the glam squad, but, So there you are. There are the two latest hearings in the Lori Vallow Dorkbell trial. We will be watching this. Sal may be able to get into some of the days of voir dire, so we might be able to, see what he thinks, his general impression of, this godly being on earth, this dump truck of holiness, if you will. We will see. And I will be getting or finding my blonde wig because, voir dire and this trial is upon us. She is such a dork and so ridiculous. And I feel bad for the witnesses that they have to be interrogated by this jackass. That being said, I hope you guys have a great day. Let me see who I can send you to because I am going to become a professional YouTuber. I swear, this year is going to be my year. This has been not a great year, but I'm going to get better. So let's see who is a-going right now that I can send you to. All right. Well, it looks like Defense Diaries is doing something with Karen Reed, so I will be sending you over there. Hopefully they are still live. But Defense Diaries is Allie, and oh gosh, I am so terrible. Why am I blanking on the name? Oh gosh, I'm a horrible, terrible person. If you want to know also, remember that Vice Baby is also live. So if you want to go there, I am going to send you into Defense Diaries. To speak of, social anxiety, sending you guys to bigger channels is kind of something I'm going to try to start doing a little bit, even though it is way out of my comfortable zone. Because, I'm not, a big YouTuber, so sending you over to some of these big folks is a little intimidating for me, but I'm going to start trying to do it and be brave and do all of the brave things, like go to the walker store and look at some of the, more fancy walkers, so I can get my hind end out to, the outside and work on not needing a walker. So that is one of my many multitudinous goals. Unlike Lori, I'm going to have to try to do it as just a human being. That being said, not all of us can be holy beings. You guys, I hope holiness or regularness, you have a great day. Be kind to yourself. Be kind to others. But carry a can of bitch fire and a sassy mouth because kindness no longer equals doormat. So until the asshole rapture, I will see you guys later. Bye.